Unfair competition in India, we can look into one of the cases, Accord Internet Services versus Star India Private Limited. The case was decided in 2013 by the Division Bench of the Delhi High Court and is now pending with the Supreme Court as of July 2015. The 2012 agreement that was that granted BCCI granted exclusive broadcasting rights to Star TV to disseminate the content and information emanating from live cricket matches and included other copyrights emanating from recording of the live match. Now there were some companies like Circ Buzz, Idea Cellular and Online Mobile. They started SMS services providing ball to ball coverage of the live cricket matches, and hence Star TV filed suits against these companies contending that their mobile distribution rights were violated. Now these mobile distribution rights are not statutorily provided in any kind of act as such, and hence there was a claim towards unfair competition. The BCCI has actually taken a position in favor of Star TV and has supported the contention that such rights accrued to Star TV and no other entity could use the rights without the permission of Star TV. Now the Delhi High Court has come to a conclusion that, and it has mentioned in clear terms, that such a right does not exist in the Indian context. It said, creating property rights or quasi property rights in information, which is what the plaintiffs, that is Star TV and BCCI, request to this court to do in this case, stands to upset the statutory balance carefully created by the legislature through Copyright Act. In a domain where Parliament has stepped into to create a statutory regime, an exercise of creating supplementary rights in common law would result in obstructing legislative scheme, as would be the case here. The court also went on to say the argument of the BCCI that it is under a duty by relying on Supreme Court judgment in Secretary versus Ministry of Broadcasting to monetize broadcasting and other rights, and is doing exactly that by permitting Star to monetize hot news by licensing mobile rights is misconceived, to put it mildly. One can monetize or license, the court said, only that over which one has property rights. Neither Star nor BCCI can be permitted to say that mentioning mobile rights and auctioning them would ipso facto legitimize the parceling away of a right to disseminate information, without first establishing the right or exclusive domain over such rights existed in the first instance. Similarly, the plaintiffs' reliance on New Delhi television, that is the case above, is of no avail. The division bench said in that case had to deal with the broadcast of sporting events by a news channel. The court has to deal whether the defendant's conduct amounted to fair use, and they distinguished this current case from those that were decided earlier. The court also said that the rights claimed by the plaintiff over and above the broadcasting rights, that is to prevent others from publishing or sharing match information or facts for irrespective of commercial and non-commercial use, is precluded by section 16 of the Copyright Act. It is also precluded because the provisions of chapter 8 of the said act, that is the Copyright Act, if Parliament had intended such rights to exist, they would have been enacted with suitable mechanisms for their enforcement and effectuation. The court seems to have here considered the fact that section 16 provides very clearly that there is no copyright apart from what is provided in the act. So this actually gives a kind of statutory basis for copyright, and hence no other form of common law rights can be claimed as being closely aligned to copyright, and the court seems to have noted the intent of the legislature in case of section 16 in interpreting section 16. The court went on to say, in fact, the recent trend internationally to accord protection to rights in information in varying degrees or to accept the doctrine of unfair competition, especially in the European Union, is pursuant to legislative action by European Council and not as a judicial extension. To the contrary, similar proposals for extending the scope of protection judicially was rejected in a line of cases, and most notably they cited Cadbury Schweppes Private Limited versus Pub Squash. This is a 1981 decision of the English courts, reported in the Wales Law Reporter. Finally, the court said, denying the claim about the tort of unfair competition does not betray the court's reticence to protect rights in intangible or to ensure fairness in the commercial dealings, but rather reflects sound judicial restraint to defer to the Parliament's policy decisions represented in various intellectual property regimes and statutes. Here the court seems to have noted that although there can be a claim for tort or unfair competition, by denying such a right at this moment in the current case, it was not going against the general sentiment of IP protection, but they said it reflects sound judicial restraint to defer to the parliament and policy decisions that the parliament proposes for various intellectual property statutes. In some ways the court has exercised a lot of restraint in effectuating or giving effect to a new right by basing it in claims of unfair competition. The court also went on to say, equally, once we recognize that mere information cannot be subject matter of protection under common law, it becomes apparent that other means continue to remain unavailable to protect such information. By way of an action for breach of common law duty of confidence, which is a right in personam, against an individual who has come across such information under confidence and crucially is distinct from property right in such information itself opposable in rem. In circumstances of the present case, the eventuality does not arise. So that is how the court was trying to distinguish the facts of the current case from other situations where a common law breach of duty can be enforced. Some of the other forms of intellectual property rights which are emerging as data exclusivity and patent linkage, which have no strong and long basis in comparative jurisdictions, are still demanded in the current Indian context of increasing intellectual property protection. It is important to note that India does not provide data exclusivity protection, but yet the demanders for data exclusivity have made these demands in the context of the EU-India free trade agreements. So hence it is important to know what data exclusivity actually entails. Now, data exclusivity provides legal protection for test and regulatory data for a specific period of time, where any subsequent generic approval cannot be granted by relying on the data that is already submitted by the originator. So the data is safe and it cannot be relied on for granting any kind of other approvals or subsequent approvals. Article 39.3 of the TRIPS agreement does not require data exclusivity, but requires protection of such data against unfair commercial use. This standard has not been clarified in any WTO dispute, hence there is a lot of controversy of what actually should WTO members implement in terms of unfair commercial use in protecting test and regulatory data. Since India does not provide for data exclusivity, it provides for data protection by way of common law trade secret protection. Now, in India, the Drugs Controller General of India is allowed to grant permission by relying on the data submitted by the originator. Hence, the obligation on the DCGI is primarily not to disclose the data, but permissive reliance is allowed and is not covered by the common law trade secret protection. Patent linkage is another demand that has been made by the pharmaceutical industry and also the agrochemical industry. Here, in the context of pharmaceuticals, a DCGI, a patent linkage mechanism would mean that the DCGI is required to police patents, but actually the DCGI is not a mechanism to police patents, because patent rights are primarily private rights, and whereas the grant of regulatory approval cannot be made contingent to the status of the patent. Now, the question of whether Indian IP regime broadly put read along with the regulatory regime of the Drugs and Cosmetics Act actually requires patent linkage. In this connection, we can recall the case of Bayer versus Union of India, a case which is now pending with the Supreme Court as of July 2015. The division bench of the High Court made certain observations, and the division bench was actually reading in appeal or sitting in appeal from the single judge bench decision of Justice Ravindra Bhatt. Now, here it was contended in this case by Bayer that section 48 of the Patents Act, the patent holder has an absolute right to restrain anyone from making, using, offering for sale, selling or importing the drug covered by the patent subject in India, which in this case was sorafenib tosylate. Further, the petitioners also argued that section 2 of the Drugs and Cosmetics Act stated that the DCA, that is the Drugs and Cosmetics Act, shall be in addition to a law and not in derogation to any other law, which would include the Patents Act. So, consequently, a combined reading of section 2 of the DCA along with section 48 of the Patents Act provided the concept of patent linkage. This is what was agitated by the petitioners. Now, petitioners also relied on what a unique section, that is section 156 of the Patent Act, which read as that there is they wanted to read as casting an obligation on the government not to infringe patents. So, they said that when you read this along with section 48, it obliges the DCGI, whose office is part of central government, to ensure that the patent granted in favor of buyer is not infringed by the granting of marketing approval to Cipla, which is a defendant in this case in respect of imitation of Bayer's patented drug. The DCGI thus would be party to infringement, and hence section 156 of the Act does not allow government to actively support such kinds of infringement.